Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And Justice Served TV is on the air. How are you, Linda Kenney Baden?
Oh, been a busy day, Michael Bryant. I started doing for Justice Served TV an interview on the Karen Reed case with Ted Daniel, who is really 3 years of his life has been spent on this case. And
he's at 25, right? Is that BZ 25, or do I have the wrong station?
Well, I think this was done for Court TV. Was this done for Court TV or?
I'm not even sure. His station. I think he does that thing side
from Court TV, right?
But I think it's BZ. But anyway, go ahead.
Anyhow, he's wonderful. Believe it or not, I've been doing interviews since 12:15 today, including my own work and other things that have been like crazy. And you and I have been obviously prepping for our shows and all. But I think I don't have the link to it. I know you have watched it. And if you find the link, let's post it.
I was trying to just narrow down the. I think if you
there it is. There it is. Oh, Missy.
There you go. There you go.
I haven't even seen it. We posted on X and our Instagram and any place else in here. Missy says they just watched it. Thank you for letting me know, because we did have a little glitch in the middle because I'm out in the country and we were having a storm, so my Wi-Fi wasn't exactly perfect, so they had to cut probably about 9 minutes, maybe not 9 minutes, but a segment of it out that we had done, and then everything went great. Thank you all for saying it was great. I don't know, they were supposed to say Justice Served TV, but
on the posting it does say that.
Yeah,
and he is with Boston 25.
Boston 25. I'm sorry. I mean, he and I were both watching the Court TV stream in the background yesterday of the Reed hearing, and also because we couldn't stream yesterday. Our schedules were so busy. But as you know, we did our first show yesterday and all. And so, I mean, there was also I had something about a rip and read. Oh, rip and read. There's something going on with Mr.
Okay, hold on.
Hold on.
We have crazy production elements here. We don't want to miss these. All right.
Rip and read. There's something, and I'm going to let you talk, but there's something going on with Robert Cosgrove. You know who he is?
Oh, my God.
Another special prosecutor in the Aiden Carney case after the other first special prosecutor.
They're also special.
You know, they're all so special.
Not like FBI special agents. They are special. And it still fascinates me that they have no regular prosecutors in all of Norfolk County's DA office, Michael Morrissey, that can handle these cases. They've got to go outside. Special prosecutor, which means tax dollars, like Hank Brennan, $600,000, and you will never see or hear from him again.
Yeah, but I have to tell you, just before we get off to Ted Daniel, it really was, he was really gracious. He was wonderful. He was terrific. And I had massive respect for him on handling the Karen Reed case. And we've posted some of his interviews that he's gotten. I mean, and I think that his whole next 10 years of his life is going to be devoted for this. For
that, I feel sorry for him, because that's brutal. At this point, a lot of it's just, judicial theater. The important stuff's been decided. So aside from maybe someday finding out who was responsible for Officer John O'Keefe's death, but all of this civil stuff is, which we're going to get into, because we, as my evening at the river wound down last night, we didn't get done really talking about that hearing that took place yesterday. Not going to hear a thing officially about this case again until November 21st, the Karen Reed civil case. Mm-hmm. But I'm sure there will be all kinds of smatterings and drippings and details that come out from the players or sources to give us a sense of what's happening behind the scenes. Because with all of the talk about adding defendants and the procedural nature of bringing in the entire McAlbert clan, I mean, there's going to be a lot. I guarantee there's going to be a lot said about that, whether it's official or unofficial.
Now, matter of fact, we addressed this of what may be happening in the next 2 months. in the Ted Daniel interview. And I said, you're going to be hearing a lot of things happening in the next 2 months. I mean, this was the bow across the. This was this was the shot across the bow of the boat, right? This is clearly, no doubt in my mind, we called it the civil case in quotes, but basically we're calling it the war zone here in Justice 13.
It was a presser yesterday.
Both sides were pressers. I talked about that. That was you're hearing both sides pressure, and then I talked about some of the law that we're going to talk about tonight. The entire controversy doctrine and Monell claims and what those mean. And those are legal terms, but they're very significant in the planning of what Alan Jackson plans to do and how the judge may be stuck with some of these claims because he doesn't want them. He just wants to clear his calendar. Case solved. Case,
Oh yeah, there's no doubt. The better way to resolve this is get together. There are ways to get justice that fall short of trial. Blah blah blah. And so before we go back into what happened in the court, let's look at what happened outside the courtroom. Because it was very much an impromptu press conference with your good buddy.
My good buddy Alan Jackson, who
he loves you, I hear. Yeah,
we have mass respect. We tried a case against each other, and when two good attorneys clash, whoa, you develop respect.
Let's see if I can play this.
Okay.
Poor girl. The whole change in tactic, right?
I think we're a little offensive during the criminal trial.
How does that work?
I need a fullback.
Y'all didn't even let her get a blocking back.
We can move quicker.
Alan,
can you help me understand what an affirmative claim is?
What an affirmative claim is? It's an affirmative claim against the third-party individuals. That's exactly what we intend to bring.
But the idea is to get them combined to save the court time and money.
All the same individuals are involved, so that's exactly right. It's a matter of judicial economy.
You respond to the psychology. Longer if you do this, you have all these.
Well, of course, because it becomes a bigger case, more voluminous, right? It's a bigger case with more claims, and that's exactly what this case calls for.
How did you determine
the days of Karen Reed being on the defense are over? Right. That's what started today. That's what we're seeking today.
What do you think of the judge say trying to resolve this? Can you resolve this out of
court? Every single civil case should at least have that on the table. Civil cases are built and designed to be resolved if they can be. We'll see. It depends on how reasonable the other side is.
Was that something that you guys would like to do, though? I mean,
Say it again.
Was that something that you guys would like to do, or do you want to make a point?
Anytime there is a civil case, look, civil cases are not about making a point. They're about trying to seek the truth, right? And that's what Karen's going to do with this civil case. We're going to try to get the truth out there. Like I said, the days of her being on the defensive, those days are over.
So you said
everything that you heard in there was basically parroted. Every single word that you heard in there was basically parroted right from Michael Morrissey, right from the prosecutions. They lifted it right off the prosecution's closing argument. And maybe somebody should check the tapes. Because last time I checked, those arguments were put forward in front of a jury, and the jury spoke very, very loudly. Not guilty, and not just not guilty when the jurors were asked, innocent. Those claims are false, and they were proven false, and they will be proven false again. But in terms of what you just asked, should this case be resolved? We're always open to resolution. We'll see. It depends on how reasonable the other side is. We got to go.
Damon, did you want to say anything? I mean, you've been sort of point person on this, or?
Well, Ellen says it all as in a perfect way. So, what we're trying to do is make sure that Karen is well defended and that the claims that we have to pursue for her affirmatively are brought in the same proceeding in the most efficient, judicious way so that her day in court is fully and fairly adjudicated.
But if you combine these cases, isn't that unfair to the O'Keefes?
Not at all. Part of her defense is that somebody else put her in this situation. And so that's when I said it's not your typical wrongful death action. Karen Reed is in this situation because of the behavior of others. And as Ellen said, she's no longer on the defensive. She's going affirmatively. And we're trying to put all the evidence, all the parties, all the claims in the same proceeding.
How did you decide on who to name in the counterclaim?
I'd love to tell you that, but it's really sort of a litigation strategy point. So unfortunately, I cannot get into sort of discussions behind the scenes.
So do you plan to prove that someone else killed John O'Keefe?
We plan to show that Karen did not.
But that's not the same as proving someone else did.
We're going to let the evidence play out. I'm not able to tell you that yet, but I can tell you that she did not.
How about, can you spell your first and last name for me, counsel?
Sure. Damon, D-A-M-O-N, Seligson, S-E-L-I-G-S-O-N.
Thank you.
All right.
I could listen to him all day. I said that
He's,
today.
you know, he's
South
got
African accent.
Yeah.
It just
very,
and also,
very proper and very sophisticated and very articulate. Yeah, you know.
when somebody says, "How do you spell your name?" That's always the situation. Whenever you're in a case with a high
Yes,
profile,
yes, it is. It always happens
for
once.
you.
Yeah, once. By the way, you are, yeah, and you know everybody flocked to Alan Jackson, obviously, and he's with Karen Reed. So of course, I felt kind of like I should be there. I feel like there's all my buddies hanging out. I wasn't there, and so then this guy trails on the play, and Alan Jackson didn't say one word in court, you know, other than Alan Jackson representing Karen Reed. So it's kind of, puts a Damon, if I may use his first name, puts him in kind of an odd position, but you know, he's a pro.
And he's a great attorney too. I mean, he has a great reputation.
Of course.
He's a pro. But it's always, I tell you, I've been there with him. And who? How do you spell your name? You know, or the people always look over my name. They always call me Kennedy. It's just a matter of happenstance. Because
and you're Baden, and you're Baden, and you're.
And I've lost my identity as Kenny. I'm Linda Kenney Baden, and I keep saying that's like Arthur Conan Doyle. But you know, as long as they spell it right, it's okay.
It's halfway there. Yeah. So, and, you know, the guy understands that's part of the deal. And you know, especially with a case like this, which is it's not going to be in the news every day. You know, Karen Reed was in the news every day forever. And let's face it, you know, this is not that it's unimportant, but it's the toy department compared to a criminal trial.
Right.
You know, it's all about the money, blame, you know, and it's intriguing. And because the same players are involved, it's interesting.
And the judge is treating this like this is a civil case, like a normal civil case. This is somebody who was tried for murder twice. This is not, Your Honor. You know, this is not, as I call a run-of-the-mill, Your Honor, Your Honor O'Shea. You know, car accident. Oh, he hit me in the rear. It's simply not that. It's not even a medical malpractice accident. This is a woman who's tried for murder twice. Come on.
True. But I mean, to his point, it is a wrongful death case. That's what it is. We're not going to turn it into something else. We're not going to turn it into a quasi-criminal trial. It's a wrongful death action. But we saw it. You know, we saw it with OJ. You know, we saw the same thing, right? They're different standards, and if you couldn't get your justice, if you're the O'Keefe family and don't believe you got justice in that trial, maybe you'll get it in the civil trial. It just ain't the same. It just doesn't rise to that same level. But this one's all about circus environment, posturing, press conferences, the actual guts of the case. I don't know how much of that's ever going to really be.
Well, except it's not your ordinary case in this regard. And this is where I said that Diller, the plaintiff's attorney for the O'Keefes, lost me. When he started bringing, and it's, you know, it was Turtle Boy and the conspiracy with Karen Reed, and Turtle Boy said the O'Keefe's family time for grief is over and all. That's where he lost me, because then he made it not into an ordinary wrongful death case. He made it into a conspiracy criminal case also. And to me, that's where this went off the rails with him. He could have just kept it there, and he went off the rails as far as I was concerned. Now, he can always win me back, but I think it's going to be very difficult.
Yeah. And again, I think that's what happens when you lose the real trial. I'll call the criminal trial the real trial, the second one. When you lose, and this is all you got, you try to make the best of it. And I just don't think it's fooling anybody.
Our Cheech said he lost me when he JJ. Yeah, we never heard JJ before.
Yeah, I thought that was very interesting. It was like, let's get folksy here. Let's kind of humanize the guy that. And the thing is, there's nobody on either side of this case that doesn't feel for the death of John O'Keefe.
Absolutely none.
So it's not like, you know, there's evil people on the defense side and they hate Officer John O'Keefe. We love JJ. They hate Officer John O'Keefe. That is not the situation here.
No. No, everyone understands that he took in his niece and nephew. Everyone understands the heartbreak. But we also heard that, as with every human, he had flaws. Okay. And then, driving, asking Karen to drive him because maybe he was drinking. All the cops up there seem to be drank, right? I mean, and they have flaws. We all agree. We all have flaws. I have flaws. You have flaws.
No.
Yes, I have flaws.
No, I'm not.
Yes. I just, but when you're doing a press release, you got to make sure the people that you want to appeal to, are on your side. And maybe he was appealing to the jury because remember, he only has to take 6 people and he only has to go, preponderance of the evidence.
Yeah. Oh, it's definitely an easier case to win. And again, we've seen that before. We saw it in OJ. Being liable is not being guilty, and it's it's a distant second place. If you're the one looking for what you believe is justice, a civil victory is a distant second place to a criminal conviction. But it's all you got.
Considering there was Turtle Boy and the rip and read.
Oh yeah, we kind of jumped past the rip and read with the Cosgrove. Yeah. So
you want to do your rip and read? So
he'll be there tomorrow. I did it once. Can we do it again? Is that illegal? Can we get away with it the second time?
Right.
So, Special Prosecutor Cosgrove will be there tomorrow because he is still involved in the Aiden Carney case. He is still the special prosecutor, but he has tried to remove himself. I don't know that the court has ruled on it yet, but he has made a motion to withdraw as counsel in the
Lindsay Gaetano case, right? That involves
imploding. But he did that because basically she sued him. It makes it very difficult to be involved in the prosecution of a case when you're, well, at the very least, a witness, perhaps a party. So that's certainly going to be granted. Again, if it hasn't been done in the hallway somewhere, I don't know that it's one of those motions. Quite often, a motion to withdraw, you have to convince the court that there's a reason because generally you're stranding your client, in this case the Commonwealth. Not as big a deal when it is the Commonwealth because they have other bodies. It's not like a defendant who has a public defender. Anyway, in this case, you're not going to need those kinds of burdens of proof to say, well, here's why I have to get out. It's a conflict because this is, well, yeah, I'm named in a lawsuit involving one of the parties.
Kind of a conflict. By the way, Michael's going to be making, I think it's his 20th trip up tomorrow to Dedham. It's actually, you're going, are you going to the Dedham courthouse or are you going to Yeah. Okay.
Well, I hope so. I hope that's where it is. Norfolk County.
It is, right? And tomorrow, say, remember, there's a mega motion on. What do you remember what that was about, Michael Bryant?
Oh my gosh, what was it not about? This was, I think we could say it was fully throated. Can we say that?
Yes, we can say
and
that.
I think it's 88 pages. I'm getting fuzzy on that because we've been reading so many very long documents lately. But it covers anything and everything that is developed in the cases against Aiden Carney, intimidation of witnesses. Those are the core charges against him. And all of the interactions between the players. And, Aiden has so many nicknames for these different people that I sometimes forget the real names. But Kate Peter is in the eye of this storm, right? And she is being portrayed in this motion and all the evidence that is included in the motion as basically an agent of the Commonwealth and was
no doubt in my mind, as legal as she is. I mean, whether it's in Massachusetts, they consider it, but no doubt in my mind, she is.
Yeah, well, it's a factual issue. You have to evaluate it. Is she acting on her own? Is she acting for the state? Are they encouraging her? Are they paying her? Are they? What is that connection? And so that's a big thrust of the motion. It's a motion to dismiss. It's trying to get rid of the whole enchilada. Not like the motion to dismiss in the Karen Reed case from yesterday, which was to attack certain causes of action in the civil case, all related to emotional distress.
Right.
This
10 through 13 counts 10 through 13.
That's right.
Guys, if you're
10 through 13. If they're generally at the end too. That's normal in most pleadings. That they kind of throw those in at the end. So this is to get rid of all criminal matters now. As well as it was written, Mark Betterow did fine work. He and whomever minions he might have had helping him.
Well, I don't think you can call Olivia Lamb is actually. I didn't call Olivia Lamb a minion.
Can you call her attorney?
No, but she knows this case inside out, and she's just fabuloso. And it's 100, I think with the affidavits that Federal filed, it's more than 120 pages because Federal filed an affidavit.
With all the exhibits.
Mello, which is the first attorney before Cosgrove, who has to get out, right? Had to get out.
And he had to be really shoved out. He had plenty of opportunities, but he was
to be shoved out. But Federal said that he intentionally and repeatedly elicited false and misleading testimony from the Detective Brian Tully, the lead investigator in the Carney case. And everyone has said, people have said that they believe that Tully is the one pulling the strings in the Karen Reed case. He was the one pulling the strings.
And technically he was the supervisor, but apparently they don't really have any responsibilities. They're just a supervisor. So,
right. Well, look at this. They changed the names of episodes that Aiden Carney did to say intent and all. They changed it and then presented that to the grand jury without really what they are.
To me, that was when I read through the whole thing. All the other stuff is salacious and very soap opera, and makes you take sides. That's for sure about what is right and what is wrong. But to me, if you're indicted from the grand jury, again, that arcane system that I think sucks, and this proves it really. If you're being indicted because the grand jury is presented with evidence of your intent to intimidate, but that core of that evidence is manipulated headings or titles for shows that Aiden Carney did that are far different than the real ones that show greater intent. What do we got here? Well,
we have a system that really should be torn down, and people that should, in my opinion, be prosecuted, and people that should be indicted and all, because you're ruining people's lives here, and it's just ridiculous. People don't realize how the criminal justice system can ruin people's lives. And thank you, George Schmeyer, the attorney. She believes the plaintiff's attorney in the O'Keefe case is an ambulance chaser who wants to get famous to 6. Well, everyone has their
never heard of that
15 minutes of fame. Thank you for the donation. You'll go to buy more tapes in the Donna Adelson case. You'll know that. You'll understand that Thursday when I talk to you.
Yeah, that's right. We got a fund drive for body cam footage from Donna Adelson. Stay tuned for that.
Yeah. And she says she'll see you tomorrow, Michael Bryant.
Come on down.
Come on down. Come on up. Or I guess yours says you're going up, right? You're going north.
Yes, I'll be going up. Come on down to the courthouse. To the trilogy of terror.
And so Cynthia Lynch says when you're shooting, it donates $9.99 for your super sticker. That'll help with the gas tomorrow. Thank you very much. And I have a very important one from Joey.
Yes.
Yes, cinnamon or chocolate.
I'm gonna go chocolate. It was cinnamon last time. I'm gonna go chocolate this time, just to go crazy, mix it up.
And that's because Joey Kane feeds Michael when he gets up there,
that's
because doesn't allow for Just to Serve TV to feed Michael.
No, that's not in the budget. So we'll have our normal kind of a setup before the 2 o'clock hearing. Then we'll have the post, and then we'll have our normal 6 o'clock show, and hopefully, I don't know, scrounge up a guest. We'll see how that goes.
Yeah, we'll see. There's gonna be a lot of there.
We want Joey Kane. We want Joey Kane to come on. He's hiding behind the cinnamon roll.
Gifted 1 Justice Serve TV membership, and for that, I just will say you have to subscribe here. You have to be a subscriber because those are automatically given to subscribers in our feed. All right. And if you're not a subscriber, you don't get one of those. So when people love them, it's probably already been randomly assigned. But subscribe, like, share, notify. We seem to be out of Facebook jail after we spent like 10 days trying to get to 28,000 for our 1-year anniversary, which we did the day after. We're now gaining another 400. So Facebook has let us out of jail. We didn't even know why we were in jail. But, that sounds like
I'm not sure if there was probable cause for the arrest, let alone any conviction. But we're definitely bound and gagged, no doubt about that.
Yeah. That's definitely.
So now let's see where we are now. We're somewhere near 28.6, I think. Yeah, somewhere in there.
So we're out of Facebook jail. I felt like we were in the Sacco and Vanzetti courtroom, right? No way out. We're about to be lynched, but we're not going to be lynched because they were actually, that things didn't go well. They were wrongfully, at least one of them was wrongfully convicted.
One of them, one convicted, one not. So, and we're in the big courtroom tomorrow, which is nice. Everybody can get in there and hang out if they care to. Might be better attended tomorrow than some have been in the past. And they've been, I would say, 80% full in the past, the Aiden Carney hearings. But because this one has some balls to it, it's a little weightier than some of the other stuff we've seen. So, yeah, we'll see.
And Missy, have you emailed Jimmy, or he owes us one? They would say we're like the Godfather. I'm going to make you an offer you couldn't refuse, or, do you a favor because then you
what's the offer? What's
the offer is he's
offer?
got to come on the show. Jimmy, Danny, Deb, we want you. We need you. We love you. It's makeup time.
Yeah. So I'd say there's a 50-50 shot. That's my guess. Well, we'll see who else is out and about and around. It always is an interesting collection of folks there that we've come to know, and we appreciate it. So, so what else do you expect to come out of this hearing tomorrow? I mean, let's first of all, there will be no ruling in the courtroom, guaranteed. It just doesn't happen.
No,
it just doesn't happen. And so it will be taken, in California, judges would say under submission. I'll take this under submission.
New Jersey,
they take it under advisement.
Yeah, New Jersey under advisement.
It's the same thing, but whatever. Advisement is somebody advising you. You can't make your own decisions. You need to be advised. That's why in California makes more sense. I'll take this under submission. It's been submitted to me. Now I, in my infinite wisdom with the black robe, will figure it out. But on the East Coast, it's more advisement. So all the advisement you need to get there, Judge Doolin, whatever you need, get some advisement. It won't happen in court.
Before we go back to then the O'Keefe hearing, okay, since we're talking about screwed up or as effed up legal systems, because we don't want to get dinged. Although YouTube said they don't ding you for
YouTube changed that. You can say curse words. It's in the first few minutes. That's what the distinction's been made. I'm not sure what happens after the first few minutes. But in the first few minutes, you can drop F-bombs now.
Oh, wow.
But after that, I don't know what that means. Right? We don't do that a lot anyway.
Can we do another rip and read? Because I do have one that just came hot off the presses. Hot off the presses. If you're not in Massachusetts, you must be in the state of Georgia, because they have just filed an appeal to reverse the ruling that gave young Thug all his seized property back. That's according to Thugger Daily, our friend Thugger Daily, who's been reporting about this. Yes, state of Georgia plaintiff versus $149,426 et al. Defendants. Okay, Judge Whitaker. The state of Georgia initiated a civil suit for forfeiture of personal property from a criminal enterprise. This is an appeal of a superior court order which dismissed the complaint. Given that order, the case is no longer pending in the superior court, so they are appealing it. Okay, so if you're not here, you're there.
It's
Massachusetts,
pathetic.
Georgia. I think we need an AI song of Massachusetts.
Fulton, Norfolk. Fulton and Norfolk.
Fulton,
I'm not ready to
okay.
indict the entire state of Georgia or Massachusetts, although Massachusetts is tempting me. But certainly these counties are all effed up.
Yeah. I mean, and
I can't believe what do they think the grounds are going to? First of all, they blew the deadlines. If people don't remember, back in Fulton, you have 60 days for them to basically complete the seizure, and they didn't do anything. And so the seized, and again, it's styled, as you just read, as the state versus the property, not a person, against the property. Right. And then the person who owns the property is there in the stead of the property. You say, yeah, I want that back. They blew the deadlines. The property was granted to be given back. And now the state, the state says, no, we really should get to keep that. Maybe they've already spent it. That's probably it. That's probably it. Connie Willis has already spent it on something.
Yeah, Connie Willis has already spent it. And then also, remember, she just lost the whole Trump appeal, that Trump case appeal. No matter what you are, Democrat, Republican. I mean, she is, why did she lose it? Because she had her lover, although it was disputed.
They're back together, though. Those
they're
crazy
back together
kids.
now. Yeah, the special prosecutor. And I mean, you can't make this up. You really can't. Okay. This is not how I was taught to be a prosecutor. This is not how I was a prosecutor. And so I guess that when I look at prosecutors now, I put them against the moral standard that my senior prosecutor, the late Al Lair, who had been a defense attorney, talked to us about. And that is, honesty, morality, do whatever it is right. Okay. So I mean, I just can't with these prosecutors.
Yeah,
right now.
it's unfortunate that has to be a surprise. Like, oh, what? You don't have any sort of moral compass here. You're representing, right and wrong, law enforcement. It should be the default position should be, I don't know, doing the right thing.
Typical man.
So
doing the right thing.
yeah, we'll see if they're successful. I'd be shocked, but who knows? The fact that they're just attempting it is just disgusting.
And of course, where is the Richard Miller watch?
Yes.
Miller
Yeah.
watch.
Yeah.
Where
I
is
think
it?
check Nathan Wade's wrist.
Richard Miller watch. Okay, it's going to appeal at some point. It will turn up when it gets not pulling, but when it goes to a secondary seller.
I mean, those kind of watches, they're worth $250,000, give or take. They're tracked. I mean, they have numbers. They have a history. It's tough to sell one on the black market.
Yeah.
So
thank you very much for that. Thank you very much for that. Where is the watch? Let us not forget the watch. And I did post this, Katie, Boston Katie, Michael, Michel as my series. Mais oui, especially we're talking Richard Miller. Love that you are
local.
Another visit. We think of you as a local now.
I'll see you at Dedham Pizza. That's my plan. I do the whole thing, then we do the post, and then we have a couple hour break before the 6, and I go right to Dedham Pizza. Michelle's great there. I may or may not have an adult beverage while I'm waiting.
Well, wait a second. You're going to have one now because Susan Khan's 57 Glare, Will the Glare will be. I think he's coming.
Oh yeah, that's right. Oh, then I'll get him to buy me one. Yeah,
you get him to buy you one. Maybe
get him to buy me a beer. I got Joey to give me the cinnamon roll. I'm sad.
Yeah, and if we could get Jimmy to do your makeup, that would be great.
I don't think Jimmy's buying me anything.
No, if we can get him to do your makeup.
I'll do my makeup.
Makeup, like they do in the real TV stations. And of course, we're also trying to get Aiden on, not for tomorrow night, but for another night this week or next week.
Yeah, we actually were trying to get him on tonight, but he was jammed up, and he has his show at 9.
9, yeah, I understand.
Where you can imagine that's going to be kooky because it's on the eve of his, big court hearing. So
yeah. So a fan of truth. See you, fan of the truth. See you there.
All right.
Michelle. Okay. Yes, thank you very much. And Donnie Nut Wahlberg gives it 1 Justice Serve TV member.
Donnie, make sure you let us know when you get your mug, when the mug arrives safely.
Because I'm very concerned about
Duffy. The mug in transit issue.
Yeah, we don't want to be another Sheila Duffy where we still laugh about it.
All I will say is it's domestic, so there's a much better chance it will get there.
Oh, Lordy. So with all that, do we go back to the hearing now?
Yeah, we didn't get to all of it, and there's some stuff we're talking about. If we want to pick up, where were we when we left off? Was it?
We were at Diller's. We didn't finish all Mr. Diller. His name is Mark Diller. We didn't finish his, shall I say, press statement, which was his opposition to the motion. That what happened is the defense filed a motion to dismiss counts 10 to 13, the infliction of emotional distress, negligent and intentional infliction of emotional distress for the family members. The plaintiff then gets to oppose that. So they submitted papers, but Mr. Diller decided he wanted to not rest on his papers to make an oral argument. So we at 1.25 time yesterday listened to the first a third of it. Shall we at 1.5 time now listen to the rest of it? And then
that might be the best way to listen to him.
Okay, so. Let's do it then, Missy.
From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where Let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Semino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Semino case, Your Honor. Semino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Semino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. But the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who bought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone, does not experience the injury, and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim. To suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes,
Missy, we have to
I
put
refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other...
He's not pausing. There you go. We have to put a pause because we have an auction going on in our feed. Everybody,
I heard 5.
I saw 2 5s. Okay, do I have 10? Do I have 10 memberships to go to other members? Not to us, to go to other members. Do I have 10 memberships? Come on, 10. That's 10 there. Come on, there we go. 10 memberships. Okay, let's stop it. Joy Schmehar came through.
Thanks, Joy.
Thanks, Joy. And everybody
okay, so
else come through.
Let's talk about this blowhard. Let's talk about this blowhard. You know, first of all, here's what I can't wait to see. Let's assume these causes of action survive: the negligent infliction of emotional distress
and they're going to survive summary judgment.
Of course. Well, I don't know. Summary judgment may come up.
Motion to dismiss. They're going to survive right now.
There's no doubt. There's no judge that wants to be responsible for cutting off potential rights of a plaintiff at this stage of the process. It just doesn't happen. But to recover, let's assume they prove there was some sort of emotional distress, intentional or negligent, some level. In Massachusetts, you have to prove like medical records. You got to have doctor's records. You got to have some proof of actual damage if you get the jury to believe that, oh, I guess they were damaged. Okay, so where are they? What are the damages? Some jurisdictions you don't have to get that hard and fast with what was the cause or what was caused, but you do it in Massachusetts. So I can't wait to see shrink bills. All of that stuff's going to come in as evidence of any damage, right? I don't think anybody had any physical, maybe got IBS. I don't know. That's irritable bowel syndrome.
But here's the crazy part. Like in New Jersey, when he talked about the father seeing a scene, that's because the father was in the car and you see your kid die, or you walk.
Of course, that's an easy call. That's easy.
Your husband get hit by a car. Then you have emotional distress. You have to see the actual tort.
California, it's the same thing.
Here in Massachusetts, the scene can be someplace else, and you don't.
I can tell you about it. I could tell you about it, and you could suffer emotional distress. Again, that gets to the that may get to the causation, but where are the damages unless you did something? Do you think these kids or her, the one girl, and the other folks who are claiming it, do you think they have medical records? That they have some sort of evidence that they suffered something as a result of that?
Because the suffering is going to be as a result of the father dying.
Well, of course.
The new father, the guardian father, took on top of the other father, but not because of character. Under this theory, to me, I was thinking about it. If somebody hurts a loved one of mine and they end up being buried, and I'm Catholic, and let's assume you go to a funeral parlor and you have an open casket, and you don't, you know something's happened, and you see the open casket, you then have emotional distress damages for the tort that you didn't see. Besides the tort, you have additional damages, and we're not talking about wrongful death or survive. We're not talking about the survivorship damages. Okay, the wrongful death damages go to the person, to O'Keefe, what he felt before he died. But we're talking about the survivorship damages. You have people can have independent causes of action outside it, according to Massachusetts, for intentional infliction of emotional distress, as opposed to the damages that are set forth in the statute.
And I think he misspoke when he suggested that the defense was trying to say it's either or. You can't have both. You can't have the damages that are connected with wrongful death and have your own infliction of emotional distress, negligent or intentional, as a sidecar. They weren't saying that. They were making a very obvious argument that there's already a remedy. They're not exclusive, but they've already got a remedy. They wanted to give the court at least that option that there is a remedy. If there is a damage that's based on the wrongful death, there's a remedy built in. They never said you can't have these other claims as a result. They just made it clear that there's a remedy already.
And some
I think
states
that's a fair argument.
And some states like Connecticut, if I recall, have made it a special tort. This was, as somebody brought up Alex Jones, because let's talk about this, where if your child gets killed in a school shooting, you have there's the special damages that are allowed, right? And we all understand that. We all understand that. But this, to me, it seems like you're exploiting. This is exploitative in my judgment. But
yeah, and there's no way that one of the options laid out in the reply brief. I got the reply brief, which was not redacted. The main papers were pretty heavily redacted, in part because the young girl was involved. But they say, look, hey, you can dismiss these claims now, Judge, and if through the course of discovery they learn other facts that support the claims, well, then they amend the complaint and bring them back in. So procedurally, they're correct. I still don't think they're going to win, but procedurally, that's one way to bring it back from the dead, so that the judge is not, totally killing this off, and these emotional distress claims could never rise again.
I don't know how you got bring it back from the dead and killing these off in a wrongful death case. As commentary.
Sorry. There was another couple of things here I noticed in this paperwork that was very interesting. Yeah,
Yeah. But we don't. I don't know, Mr. Damon Seligson, not Damon, who we saw the press conference, who didn't get much time. Alan Jackson pulled him in at the end, but didn't get much time there. Who's a great attorney up in those neck of the woods, right? He basically got up when the judge said, "Do you have anything else to say?" "No, we're going to rest on our papers, Your Honor." And everyone's like, phew.
Thank God. Yeah, and I always respect that, because attorneys won't shut the hell up, and they think that they have to say something. And when the judge very clearly says, "Is there anything not in your moving papers that you'd like to?" And 9 times out of 10, the attorney will stand up and say exactly what's in the moving papers, because they can't stop themselves. Okay, so here's something I found interesting. We were talking about the concept of discovery yesterday, and how in a normal case, this is far from, but a normal case, you have paper discovery that goes back and forth, interrogatories, formal questions, requests for admission. And then as you plod down the road, you get to depositions. Well, this case was filed in August of 2024, right? In October, roughly a month later, October 1st, a month and a week later, they served a request for a deposition of Karen Reed.
Right.
Very first thing. First thing. That tips you off as to where they're going and what their plan is, right? And then they have, of course, the defense went to the court and said, "Look, we got a criminal matter that's kind of underway," and they stayed it. Fine. Then what do they do? After the first of the year, this is now in between the filing of the civil suit and the beginning of the criminal matter, the second time, they the plaintiffs try to take the depositions of William and Janet Reed and Caitlin, the girl. They tried to get those set up for March 5th, and that would be about a month before the trial. So they were shut down trying to get Karen Reed's deposition. Now they're trying to get mom, dad, and the child, and that also led to the court stepping in and saying, "No, we're putting a freeze on that as well." That happened April 8th, so just before the second trial began. My point is that these plaintiffs are not following the normal course of events. They wanted to jump into salacious, deposition testimony, if not of the plaintiff, of the defendant, of her parents.
Of her parents, right.
And then they can use that material. They're looking to use that material. I'm sure some of it would leak out and try and support their case. So I don't like the way they're doing it. I understand it. I get it. I just don't like it. It's a little slimy.
Yeah. By the way, this is actually a very good comment. Legal-minded friends, Karen Cole. Gabby Petito case, parents against the Laundries had the statement called, had a case against emotional distress. And I always said that was a good case because that relied on something else. That was an independent duty after the fact, totally after the fact, after the death, not to cause further emotional distress, which was by they knew what their son had done and they were either healing, according to the lawsuit, concealing or not advising the Petito family of what was happening. And that was, to me, that was different. I always said that there was that duty, and that was a good case when people were saying, they don't have a duty. And that case eventually did settle.
Yeah, so I'd be curious. I don't know that case law. Obviously, that would be critical in making the arguments that they made. But the fact that it did resolve suggests that somebody thought they had at least a colorable right to bring that case.
Right.
Otherwise, they would have probably ridden it a little further toward trial. I don't think it ever would have gone to trial, though.
Yeah, no, it was never going to trial. But I always thought that was an independent duty, not arising from the death, but arising after the death.
This is concealing the information, right? Yeah,
right, for concealing the information and concealing what may have been significant information, including concealing the whereabouts of where it may have been the body. I mean, that was all involved. And I met the Petito family at CrimeCon the year before you came with us. We met the Petito family.
Yeah,
and
I think they've been there every year.
Yeah, gracious. They have a foundation, a more gracious family you cannot have, who've taken this tragedy and tried to do the right thing with it for a lot of other people.
What a crazy story. So sad and so rapidly evolving. Yeah.
So we know what happened. So now the judge, he kind of, as far as I'm concerned, I still have my notes from yesterday. He said there's a tracking order in place. He talked about the wrench that has been thrown in by the defense attorneys here. He said, by the next Zoom, I'd be trying to resolve the issues, okay? But he'd like to see the motion being given. So this is where people didn't listen to him all the way through. The motion being given to the other side before November 21st. But they don't have any duty to do that. He'd like to be seen, but they have no duty to do that. So
that's just a meet and confer kind of a nice thing to do, but not required.
Not required. And I'm sure the defense doesn't want to do it because they don't want the other side going into their press conference mode, right? And so they they're going to have the motion. The motion will be to file. It's the same thing that could have been resolved yesterday. Your Honor, we'd like to file a motion to allow us to bring these claims here. And instead of saying, yes, do that. All right. He said, now you can file the motion, but I'd like to see the other side get it before the 21st of November. Well, they're not going to do it.
Blah.
And I know there's been some people out there who said, well, they should have filed the complaint yesterday. I disagree. I think that Alan Jackson and David Seligson made the right move, that they wanted to get the court's permission to do it, advising them. Of course, this was a press relief, but advising the court what they were doing rather than saying, dismiss, I'm going to dismiss this right now. He may say with the motion, no, I'm not going to allow it in, but then it's not a dismissal. He's going to give them an avenue of where you have to go. And I think that it was strategically correct. I think it was rightly done. And I think had they filed the complaint, that would have been a wrong move because it would have given ammunition. If there was a dismissal on the basis it doesn't belong here, it belongs somewhere else, all you would have heard from plaintiffs, dismissal, dismissal, dismissal,
And remember, they haven't even responded to the original complaint. So procedurally, it would have been odd to do as well. And so when talking about all these folks that they want to bring in, the Massachusetts State Police, Canton Police, Brian Tully, Buchanan, Proctor, all the McAlberts, and then it was interesting. One of the reporters asked Damon, can you tell us how you picked those? I don't know. I can't imagine how he picked those people. Just did he have it in a hat and he just pulled names out of the hat?
Where's that been? Where have you been?
Yeah, and he made it sound, his answer made it sound like it was a deep strategy we can't really reveal. No shit. Everybody knows all of these people, all of these names.
Now, the other thing I mentioned with Ted Daniel, there's a reason for this, and this is very interesting. New Jersey and many federal courts, but New Jersey in particular is the one that really started this law for like 25 years ago, has something called the entire controversy doctrine. That means if you have a claim that is anyway tangentially, you could be just like hanging by a string or a thumbnail related to a claim that's already filed in court, you have to bring them. Or if you're going to file a claim, you have to bring them. Okay, you have to bring them all in the same case. You can't piecemeal them. You can't say, I'm going to bring my federal claims here, I'm going to bring the state claims here, I'm going to bring the defense claims here. They want everything at once. So all these claims in New Jersey, by the way, would have to be filed. And then if the court decides they don't want them filed, they would say, okay, then you can go here, you can go here, and you'll go here. But the danger, if you bring them and they get dismissed, that you could actually run afoul of a statute of limitations, right? And all. So New Jersey has that. Be prepared for that to bring its head sometime, called the entire controversy doctrine. And the reason they're bringing the claims against the state police, and you heard in their individual capacities, is you can't sue under a federal statute certain state actors like police or a town or a state in federal court. You have to sue in a capacity of you didn't train, failure to train, or an individual capacity.
Or supervise. Yeah.
Right, individual, and that's why you heard failure to train or supervise or retain, because that's what's called a Monell claim, and that gets you out of that ability to be precluded from bringing that claim.
Thanks, Pro Gamer. But it is Norfolk County. Is this a rhetorical question? How can they have trials there? I don't know. I don't know. They're still trying to figure out how to have trials there.
Well, they've been trying that since Sacco and Vanzetti, haven't they?
And in the federal system, you can have a motion brought for failure to bring an indispensable party, which is a similar concept.
That's an interesting thought, right?
If you've left them dangling out there for whatever reason, you can be forced to bring that person in.
So anyhow, I don't know. Besides, I'm kind of looking forward to the blue man face group, whatever person. Again, I'm kind of looking.
Oh, their expert? You mean their collision expert?
Yeah, because they say, look, we need more money to do the testing that we didn't do. Remember, I don't know. I mean, I'll guarantee you they have somebody. I'll guarantee they have to.
Well, yeah, I think if they don't have them currently, they will. They'll get somebody. You can always get an expert. But they better be a lot better than Blue Man Crew, because that guy was a joke, a laughingstock. And I can't believe the Commonwealth heard his pitch and said, yeah, I like it. Let's do it. Let's go with that. It was laughable. So maybe they'll find somebody better. And I guarantee you they could find somebody. You can't find anybody worse. So they certainly could find somebody better.
Yeah, but the problem they're going to have now, remember, the car has been given back, and there's rumors that the car has rat pee. I don't know if that's a euphemism in it, and is particularly damaged and all. And then it's wondering, well, you relied on the car, but now you've made it impossible for Karen Reed to use the car,
resell it or use it.
No, to defend herself and see exactly what you did wrong or what you left, and maybe that's another claim.
Spoliation of evidence.
Yeah, right.
That's interesting. That would be interesting to see how that dynamic unfolded, because remember, they brought the motion to have the car and the phones released. The phones have not been released yet because Cosgrove wants the password so he can get in there and find some dirt. But they released the car, and there was some work done to get it back to the condition it was, before that night. But who instigated the repairs, and how did that all play out? Because if it was Karen Reed demanding that it be repaired, because they tore it all up when they were looking at it in the Sallyport. Right. But if she was demanding it and then they did it, tougher to prove spoliation because she's the one who asked for it to be done. If they did it all on their own and then said, here's your car, all shiny and new except for rat pee, then that's...
I want the DNA test on that.
That's a better spoliation argument because they did it when maybe you didn't want it to be done just in case it had to be an issue in your own defense in the civil case.
Or they didn't protect the car properly, and I think that's
that couldn't have been.
Some people are saying that maybe it's not rat pee, but a simple DNA test, we have those. A simple DNA.
Wouldn't it be bad if it turned out to be Proctor's pee? That would be bad.
Oh my God, I'm sure it'd be human pee of some sort. I don't know.
Yeah, well, I just picked Proctor. I thought that was the best guess. Okay, so we've reached the low point.
we reached a low point, okay, or a high point, because we freely discuss issues on the show that nobody else will go. It's kind of like Star Trek, go where no man or woman has gone before, with our viewers who have all of these questions, and that's in the news. And you have to be prepared. Look, if you don't think the attorneys are talking about it, they're talking about it just like we are. Okay, absolutely, they're talking about it. Okay, just like we are. So. There you go. You now all become attorneys in the Justice Serve TV.
Yes, you graduated from JSTV Academy.
Yes, and that's it. And that brings it. So tomorrow night, we are out of. You're going to be on the air. What, about 1 o'clock?
Yeah. Well, let's see. Probably 1:30-ish. Are you joining or not? I can't remember.
I don't know if I can.
Okay.
We'll see.
All right.
It depends on that other issue that you know about. Okay.
Yep. So we'll have some presence tomorrow. Let's say 1:30.
Missy's going to be streaming you tomorrow about 1:30.
Yeah, and then I'll go into the hearing. We'll do some post interviews, and just keep me posted on your availability, because if I'm hanging out post interviews, the desk will be empty. So
and 6 o'clock at our 6 o'clock show, which you're going to do from there. Again, Justice Serve TV, Rosemary Gallagher, she'll be there. Everyone, find Michael. Find Michael. He needs
come
friends.
on by. You don't even have to bring any food. Just come on by and say hi.
Yeah. And then we'll try to stream the Turtle Boy case if it gets streamed, and then we'll talk about it. And
that's always a question.
Where's Jimmy? Yeah, we'll be trying to track him down.
Last time, was it audio only, or was there video and audio? I can't remember.
They did audio, and then they released the video the next day, I think, on the first hearing. And I think last time they had the video at the same time.
But was it the court video, or was it?
I don't remember to be.
I know the court video is horrible there. It's really just a static shot on the judge.
And I saw feet. I remember seeing a lot of feet.
Yeah.
So
whatever is showing, I'll provide some insights as to what it was really like when we get done with the hearing. That's all we need. We'll talk to Mr. Bradel. We'll talk to Aiden, and we'll get some details for you.
Yeah. So 1:30 tomorrow, and then
All right. What do you do before we leave? What are we reminding?
Please hit that subscribe, the share, the like, and the notify button. Get us to 30,000 quickly.
All right, then. See you tomorrow, everybody. I'm Michael Bryant. She's Linda Kenney Baden. We are Justice Serve TV, and try to do the right thing.
Riding flames, they charge with mine.